This is Democracy Watch. Mark, we have bombshell breaking news right now thanks to you and your team's case that you were litigating in Texas over their maps. Can you explain what just happened in court?
Yeah, so the three-judge panel who was hearing the challenge that my law firm waged on behalf of 13 Black and Latino voters has blocked the Texas gerrymandered map from going into effect. The 5-seat map that Donald Trump called on Texas to pass, that is now blocked by a federal court order. This is an earthquake in the fight for fair districts around the country because, of course, other states continue to move forward, including, for example, California. But for now, at least, the Texas map is blocked. And I want to say this for everyone out there who was paying attention to this when the legislature walked out. For everyone out there who then stopped paying attention when the map was passed and the lawsuits commenced. This is why you need to subscribe to Democracy Docket. I started Democracy Docket to keep you informed. And yes, the legacy media stopped watching this case, but I kept telling you to pay attention to it. Brian, you and I did videos telling people to keep paying attention to it, that there was a real chance that this map was going to get blocked. And so I hope you subscribe to Democracy Docket, and I hope you subscribe to this channel because Brian has been one of the few voices who has covered this story day in and day out, not just in Texas, but around the country. So please make sure you subscribe to this channel and also hit the bell to be alerted when new videos are posted.
And I'm going to put the link to Democracy Docket right here on the screen and also in the post description. If not just for the excellent media coverage, also for the fact that you will be supporting a team who is fighting these battles where it matters most on the front lines in the courts and winning, by the way. Mark, it's worth asking here. Talk about the irony for a second in the fact that Trump issued his little clarion call to the Republicans in Texas to redraw their maps. California said, don't do it, we'll respond. Texas said, doesn't matter, we're going to do it anyway. They passed their maps, forcing California to pass its own map. Now you have Texas's map that was struck down and California's map that withstood 4 challenges already in the courts.
Yeah, and by the way, Virginia is on the way, right? I mean, we talked about this in prior videos also. You know, the Virginia legislature is activated, and hopefully, you know, you've really pressed some other Democratic states as well. Hopefully they'll continue going forward. But the irony you point out is just, I mean, too much because, you know, like you said, California never would have done the thing that they did. Frankly, Gavin Newsom would not have become the sort of national figure and the national, you know, opposition leader that he is against Donald Trump without the Texas maps. And, you know, the most ironic part of this in many respects is that when you read this decision, what did in the Texas maps was a letter from Donald Trump's Department of Justice to the state of Texas, right? So it's not just that Texas went forward because Donald Trump told them to. It's not just that that caused California to then go forward and pass their own map. It's not just that all of that is inspiring states like Virginia. But on top of that, the reason why Texas lost this case was in large measure because of a letter that Pam Bondi and Harmeet Dillon, you know, the Trump sycophants at the Department of Justice, that they wrote to Texas. They literally undermined Texas's case from the get-go. And I was proud that my law firm and the clients we represent, the Gonzalez plaintiffs, were there to vindicate the right of Black and Latino voters in the state of Texas, alongside a lot of other lawyers and plaintiffs in this case.
Mark, I want to get your reaction to the fact that one of the judges who issued the ruling here was actually a judge who Trump himself appointed.
Yeah, the decision was written by a judge appointed by Donald Trump. And when you read the decision, it's a very long decision. It is also written from a conservative jurist perspective. Like, you know, of course, it's easy for me to say that it's a very well-reasoned opinion. It is, that it came to the right decision. It did. But I think any objective reader of it would read it and say that this makes sense, but it particularly makes sense if you are a right of center judge. So in other words, this was not a Trump-appointed judge who was somehow adopting a very progressive jurisprudence. Yes. This was written from a conservative jurisprudence standpoint, and I think that will really serve it well as it moves forward. It is consistent with the law. It's consistent with this Supreme Court's statements about redistricting and the use of race. So we've still got some road in front of us, but, you know, we're fighting.
So I want to talk about the road that's in front of you right now as this thing inevitably gets appealed. The next step after this 3-judge panel is the Supreme Court. Now, I had asked you a few videos back what the best way, what the most effective way when you argue in front of the Supreme Court, because you'll be arguing in front of the Supreme Court in the first or second week of December in a case regarding campaign finance. I asked you what the best way, what the most effective way to argue against a very ideologically split 6-3 conservative court would be, and you said to take it from the perspective of what conservative jurisprudence is. So bring a conservative argument in front of these people. That would be the most effective. You've got exactly that in this ruling, again, authored by a judge who is a conservative, who was appointed by Donald Trump. And so do you think that that will have some impact? Could that have some impact when this thing goes in front of this 6-3 Supreme Court?
Yeah, so look, you and I have talked about this. Again, another reason why I want to make sure everyone subscribes to your YouTube channel, because honestly, you and I get into these details and really give a nuanced and textured sense of what's going on in the courts, and these videos are really an important part of that. But we've talked about this before, that, I'm 4-0 in the Supreme Court. I've argued 4 cases and I've won 4 cases. All 4 of them were redistricting cases. All 4 of those cases took essentially this tact against the Republican gerrymanders that I was suing over, which is to say that they were impermissible racial gerrymanders in that the legislature used race too much. So in other words, it wasn't from the perspective of saying there should have been more use of race. They weren't cases in which I was defending, for example, the use of race in Voting Rights Act cases. By the way, my law firm has defended successfully Voting Rights Act cases in the Supreme Court, and I wholeheartedly stand behind those cases and the continued vitality of the Voting Rights Act. But the argument, though, I made in those cases was essentially the Republicans were playing a cynical game in using race impermissibly. And that is evident in this case in Texas, right? I mean, remember how we get into the redrawing of this map. It is a letter sent by the Department of Justice, controlled by Donald Trump through Pam Bondi and Harmeet Dillon. They send a letter to the legislature saying, you have drawn racial gerrymandered districts. You created what are called coalition districts between black voters, white voters, and Hispanic voters in the creation of your 2021 map. Now, this was on the heels of a trial in which the legislator who drew the 2021 map said she never used race at all. She didn't use race at all in creating those districts. But what happened is this letter gets sent and Greg Abbott uses it as the justification for a new map that destroys these coalition districts. Well, if the original districts were not drawn using race, as the Republican state map drawer said around the 2021 map, then the destruction of those districts using race was just a racial gerrymander, right? Yeah. Like literally you had naturally occurring districts in which black and white and Hispanic voters happened to be in the same district. And then based on Pam Bondi and Harmeet Dillon's handiwork, the state of Texas is told, separate those people, separate the black and the Hispanic and the white voters and put them into different districts. Well, that's just an impermissible racial gerrymander. So it's not a left of center jurisprudential argument. It is actually a right of center jurisprudential argument, which is not to use race. If you look at the opening line of this court's opinion, again, written by an appointee of Donald Trump, he begins by quoting the Chief Justice by saying, the way to stop discriminating based on race is to stop discriminating based on race, which comes from a opinion written by the Chief Justice in a redistricting context, which basically is a clever way of saying don't racially gerrymander. So, no guarantees what happens when this goes to the U.S. Supreme Court, no guarantees, where we go from here. But, this is a good example of the lawyers at my firm, and I give them all the credit here, okay? They deserve all the credit along with the lawyers for their plaintiffs and also our clients, who are 13 voters who are willing to put their names on a complaint to fight for the rights of all Texas voters. And as this case goes forward, I have a lot of confidence that it will stand.
So I want to talk about that. How are you reconciling the fact that, the opinion starts by invoking the words of a conservative Supreme Court justice. So that's going to obviously have some impact unless John Roberts wants to be so hypocritical, which certainly not going to write off. But when you have this argument that, again, invokes his own words, and yet at the same time, this is an ideologically split Supreme Court that has very often deferred to the conservative ideological position of the Republican Party, even when, they're either creating some argument out of whole cloth, as was the case when they decided that Trump could commit criminal acts with impunity, or in the event where they look at what the Constitution says and ignore it in deference to Trump, as was the case with Section 3 of the 14th Amendment and his involvement in the insurrection. And so this court has been willing to show undue deference to Donald Trump and the Republican Party's position. And so how are you looking at those two things where, the argument, if folks are acting in good faith, should stand, but at the same time, this court has shown so much deference to Trump?
Look, I have no illusions about the challenges in arguing before any court, and I certainly understand the challenges arguing before this U.S. Supreme Court. But what I can tell you is every day, lawyers like the lawyers on my team do the best job they can to make the arguments that will be the most persuasive to a majority of the Supreme Court. This is a very conservative court, so you have to meet the justices where they are. You cannot put a square peg in a round hole. The fact is, you have to argue within the doctrines that a majority of the court finds attractive and has written about. After that, it's out of your hands, right? After that, it is up to the justices to read the briefs and rule in the cases. All we can do is make arguments that will appeal to the center of the court, a majority of the court. And I ask you to judge me by our track record. The fact is, it's not just that we beat Donald Trump more than 60 times after 2020 election. It's not just that when everyone thought we would lose the North Carolina redistricting case, which was before the conservative Supreme Court, we won. It's not just that when we brought a Voting Rights Act case to the U.S. Supreme Court in Alabama and everyone thought we'd lose, we won. There's no guarantee that I will have success in December in the campaign finance case I'm arguing. There's no guarantee I will have success in next March when I will likely argue a voting case in the Supreme Court involving mail-in balloting. And there is no guarantee that we will have success here when the state of Texas appeals this, as they inevitably will. All we can do is fight hard and not be held back by norms, not be held back by outdated allegiances to doctrines. We have to fight with every tool available. And that is true whether you are like me and you are a lawyer arguing in court. It is true whether it's someone like you, Brian, who influences millions of people every week in how they get news and information and analysis about what's happening in politics. It is true, frankly, and you and I have talked about this, if you are a governor or a state legislature, in what you do, what the part you can do against the reality in which we live. Right now, we have an all-hands-on-deck moment for American democracy, and there is no room in that for sentimentality, but there's also no room in it for defeatism. So everyone who thought that the Texas map was a done deal, you weren't listening to what Brian and I were telling you. You may have been listening to what the legacy media was telling you, but you weren't listening to what we're telling you. And again, not a guarantee of success, but at least we live to fight another day.
Mark, will you be arguing this case in front of the Supreme Court?
So look, this case is going to go up on the so-called emergency docket or the shadow docket if it goes up on an appeal. So there won't be argument. We will see if the case then gets held over for full argument sometime later in 2026. There are a lot of really good lawyers in this case, including a whole bunch at my law firm that did a spectacular job. So it may be that one of them argues it. I've already got one Supreme Court argument coming up that I'm really focused on, perhaps another one in the spring. So I don't know whether what role, if any, I'd play in this one, but I promise you someone from my law firm will do an excellent job.
In the event that the Supreme Court doesn't offer a ruling, but instead pushes it over to that spring session that you were just alluding to, what could the Supreme Court do on this case? Could they uphold this 3-judge panel's ruling? And by the same token, could they also reject the 3-judge panel's ruling and keep in place the 2026 maps? Yeah,
so look, they have a few options. Number one, they can issue a temporary stay, or they've got a few options. They can issue a stay until they hear it on the merits, at which point the new gerrymandered map would be in effect. They could deny a stay and hear it sometime in the spring, and then but the map wouldn't be used for 2026. They could summarily affirm the case and not even bother set it for hearing, and then we just win. So there's lots of different options. Stay tuned to this channel and subscribe to Democracy Docket.
We'll leave it there. I'm going to put the link to Democracy Docket right here on the screen and also in the post description of this video. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.